You're listening to Beyond Borders, the Immigration Evaluation Podcast, the go-to podcast for mental health professionals who want to be expert immigration evaluators. I'm your host, Dr. Mariela Shibley, and I'm here to help you turn your expertise into impact. Let's get started. In today's episode, I want to share some observations on how asylum evaluations have been changing in recent months, how the typical presentation has shifted a bit, and what this means for those of us conducting psychological evaluations in the immigration context. Now, when we think of asylum, the picture that often comes to mind is fairly consistent. A person who fled their country due to persecution, arrived in the U.S. seeking safety, and now lives with a credible fear that returning would place them at serious risk. In that framework, the focus of the evaluation tends to be on the psychological impact of past trauma, the credibility of the individual's fear of return, and in some cases, why they didn't apply within the first year of their arrival, which is a common legal hurdle in asylum cases. But recently, I've been seeing something different, and that's what I want to talk about today. What I'm seeing more often are asylum cases that don't follow the traditional narrative. So these are individuals who did not flee their country due to persecution, did not arrive with the intent to seek asylum, and in many cases, they were actually either brought to the United States as children or just came in search of a better quality of life. So there was no direct escape from danger, no immediate threat or event that prompted them to leave their country. And now, years later, they're in removal proceedings. And as you likely know, defenses in removal proceedings are very limited. There are really only a few options available. One is to apply for cancellation of removal, which requires proving that a qualifying relative, that's a U.S. citizen or lawful permanent resident, would suffer exceptional and extremely unusual hardship if the individual were deported. The other main path is to apply for asylum, or protection under the Convention Against Torture or Withholding of Removal. But to qualify, the person must demonstrate that they would face serious risk either of persecution or torture in their country of origin. So that brings us to the change. So unlike traditional asylum seekers, these individuals did not flee trauma. They didn't experience trauma. They weren't escaping persecution. They may not even remember much about the country they were born in if they were brought here as children. But they now face removal to what is, for all practical purposes, a foreign country, a place where they may have no support, no family, no access to treatment if they need it, and no viable way to survive independently sometimes. So the basis of the asylum or protection claim in these cases is not necessarily trauma, it's vulnerability. And attorneys are beginning to build these cases in a very deliberate way. So when they meet with a client and something in the client's presentation raises some concern, whether it's a history of serious mental illness or a developmental disorder, a cognitive impairment, then they start to consider whether that person could reasonably be expected to survive or navigate life if they were deported. So it's a different question than the traditional trauma-based evaluation. So it's not what happened to you before you arrived, it's what would happen to you if you were sent back now. And for those of us conducting evaluations, this changes what we're being asked to assess. So in these newer types of referrals, attorneys are often asking us to evaluate the person's functional ability, so not necessarily the impact of their trauma history. They want to know, does this person have the cognitive capacity to care for themselves independently? Do they have a realistic understanding of their surroundings and the risks that they might face? Would they be able to access or even seek out medical or psychiatric care if it were needed? Are they capable of navigating daily life in a country where they may not have language proficiency or social support or access to services? So in many cases, we're talking about individuals who have disorders like schizophrenia or other psychotic disorders, or neurodevelopmental conditions, or a combination of factors. Could be psychiatric, cognitive, environmental. Either way, these factors significantly impair their functioning. So the clinical question becomes, would this person be safe if removed? Not based on political persecution, but on their own psychological and cognitive vulnerabilities. And this is a subtle but important shift, and it requires us to anchor our evaluations in current functioning in support systems and the realistic likelihood of access to care and safety abroad. Now, of course, we're not going to do research on the likelihood that they will have access to care abroad. That is something that the attorney will argue, but this is what we're looking for. And this is a subtle but important distinction. In traditional trauma-based asylum cases, we focus on the psychological impact of past events, the presence of symptoms such as PTSD or depression or anxiety, and how those symptoms relate to their fear of return. So in these vulnerability-based cases, the emphasis shifts a little bit. So the person, again, may have no history of trauma at all. Instead, we're being asked to assess their capacity to function in a setting that perhaps lacks structure, support, or safety nets. So the question then becomes, can this individual meet their basic needs independently? Do they understand social boundaries? Are they capable of recognizing when they're in danger? This is a big one. Do they have the insight or judgment to protect themselves? How reliant are they on caregivers or systems of support? And again, our job is not to draw legal conclusions, okay? We don't determine whether they qualify for asylum. We don't speculate on whether authorities in another country would protect them. We document what we see, the clinical picture, the functional limitations, and the kinds of support that they currently depend on to remain safe. Then the attorney uses that information to build the legal argument and, of course, supplements it with additional evidence, including expert testimony about country conditions or systemic limitations abroad, etc.
Loving this episode? I've got something to make your life even easier. Grab my free introductory guide to immigration evaluations linked in the description box. It's a game changer for ensuring your reports meet legal standards. Let me know what you think.
So let me give you an example of the type of case I'm referring to. I recently evaluated a man who has both schizophrenia and an intellectual disability. So from a developmental perspective, he actually presents as significantly younger than his age. He's immature. He's completely unaware of danger, even if he were right in front of it. He's extremely trusting, often indiscriminately so. He would, for example, accept rides from strangers, follow instructions without question, and he's very likely to be taken advantage of. He doesn't understand the motivations of others, and he doesn't have the cognitive ability to anticipate risk or to protect himself. In the US, he's been living in a supportive environment with his family. He has access to treatment. He has some level of supervision. But if he were to be returned to his country of origin, he would not have access to those supports. And more importantly, in many countries, individuals with psychiatric or developmental conditions are not protected by authorities. In fact, they may be actively ignored or stigmatized or even abused. So now it's important to say this very clearly. Again, it is not our role as evaluators to determine what would happen to the individual if deported. That is outside our scope of expertise. Attorneys rely on country conditions experts for that kind of analysis and information. So our role is to document the individual's mental health status, their functional impairments, their psychological vulnerabilities, that's huge, and their propensity to be taken advantage of or harmed in an unsupervised or unsupported setting. So we're not really evaluating fear of persecution. We're evaluating clinical risk factors that may contribute to that fear or may make the individual uniquely vulnerable in the absence of support. So these cases often come with a second, closely related referral question. Is this person competent to represent themselves in immigration court? And of course, that's not surprising. A person who can't care for themselves independently or who has significant difficulty understanding and processing information, then naturally may also struggle to participate meaningfully in their legal proceedings. So now we're being asked to assess both their vulnerability if removed and their competency to proceed with the immigration case. Now, often the same impairments that raise concerns about survivability abroad, that is, the cognitive limitations, the active psychosis, or disorganized thinking, also raise concerns about whether the person can meaningfully engage with the legal process here in the US. So these two evaluations, asylum based on vulnerability and competency to proceed, are in many ways overlapping. So in the next episode, I'll be focusing specifically on competency to proceed in immigration court. So what it means, how it's defined under the matter of mom, and what clinicians are being asked to evaluate when attorneys or judges raise concerns about a respondent's ability to represent themselves. So if these are referrals that you're starting to get, or if you want to be prepared to take them on, then I hope you will join me in that episode. But back to asylum. Why is this important? Because it requires a different mindset. We're no longer assessing a history of trauma. We're assessing risk through a clinical lens. And these cases are becoming more and more common. Attorneys are looking for ways to protect vulnerable individuals who don't meet the typical asylum profile, but who clearly would not be safe or able to function if removed to a country they haven't lived in for decades or perhaps ever. These are not trauma evaluations in the traditional sense, but they're still deeply human, deeply complex cases that deserve thoughtful, well-grounded assessment. And as evaluators, our role is crucial. We don't build a legal case, but we help inform it. And we do that by offering an objective clinical window into how the person functions, what they need, and what vulnerabilities place them at risk. Thank you, as always, for listening, and stay tuned for our next episode on all about competency in immigration court. Take good care.
I appreciate you spending time with me today. If you enjoyed this episode, share it with a fellow mental health provider who needs to hear it. And if you haven't already, hit subscribe so you don't miss my next one. See you then.